Hello, good morning, good afternoon, good evening from wherever you are. My name is Tim, your favorite HR, and this is the online HR clinic. So today we are talking about a very sensitive topic that I know we are all either casualties or beneficiaries of it, but I don't think there is a beneficiary about what I'm going to talk about. Last week we talked about how to handle HR like a boss. I talked to the employers. I talked to the staff. I talked to everybody in all levels of management and, and employment and all of that. So, but before I continue, guys, first of all, I want to thank everybody that has subscribed to this YouTube channel, your favorite HR team. But I want to encourage you, please just go down before we continue. Shuka tu hapo chini. Finya subscribe, and as you continue, like this post because you will really love it, okay? So today we are talking about a very sensitive topic, and this topic is unfair termination in Kenya. Unfair termination. There is a difference between dismissal and termination, but termination is also dismissal. So today your favorite HR really wants you to be the best employee ever, and to be the best employer ever, and to be the best HR ever. So of course I wrote a few notes for you so that I make sure that I give you the right thing, because I do my research for you as well. And guys, I'm a certified human resource practitioner, certified by the Institute of Human Resource Management, and I'm a registered HR practitioner here in Kenya, and I'm here to give you only wisdom of how to handle yourself at work. And this will be very short, by the way. So I want us to really delve into this topic that is very sensitive. Most of employees have actually gone, like in government, I've heard that most employees have actually gone as far as the Public Service Commission to appeal what they termed as unfair dismissal. Okay. Now, unfair dismissal depends on what happened. Now, first of all, let me differentiate. There is something called, under termination, there is something called summary dismissal and normal to dismissal. Na pia kuna something called constructive dismissal, and then there is normal contract termination. Okay. Now, in the Kenyan law, there is something called summary dismissal. Now, summary dismissal is where your services are terminated at work without reference to you, without even you agreeing or accepting anything. And mostly they are based on something that we call fraud, forgery, and actually fighting at work and such things, stealing and all of that. Those things can warrant you summary termination. I hope you get me up to there. Now, number two, there is something called constructive termination. Now, constructive termination, number dismissal, is where your employer makes it so hard for you to work. He makes it so hard for you to work that you have no option than to just give up and resign, if it is to resign, right? Now, that is classified under employee separation. Now, employee separation is where the employee leaves the company, either by dismissal, death, which is a natural attrition, resignation, retrenchment, or something called redundancy. Okay, now there you are separated from the company. So that is called employee separation. Now, we delve deeper into dismissal. Now, unfair termination is something that many employers think that is so easy, that you can just wake up and say, you're fired. No, it doesn't go like that. Did you even know staff that you have been working with or that you have been employing verbally without a contract, they still have a right? Because if you have paid them salary and they can prove it, then that means that these people are substantively employed. Okay. So I want you to be on the right side of the law so that you don't have to fight with your employees every time. So your employee is not anybody that you can just wake up and say, you're fired. That doesn't work like that, okay? You don't just wake up and say, you're fired. Every employee deserves something that we call being given a shock cause letter. Let's say I have gone and I have committed some maybe let's say I work in the payroll or in the finance section, and there is some forgery, or maybe people stole through the system, or they paid somebody an allowance that should not be paid, you will not just come and tell me you're fired. No, that is not true. You cannot do that. What do you do as an employer? First of all, you issue me a letter called show cause letter. Now, that show cause letter gives me the opportunity to explain myself, why I have done what I've done. Number two, you will subject me to something called fair hearing. Now, fair hearing means that when you call me for that, kind of disciplinary process where I will come and explain my case, you will actually hear me fairly. You will not question me in a way of like you're harassing me when I'm before, like the panel. No, you will question me fairly and you will listen to me, and what I say will matter in the proceedings. Because sometimes you find that you have gone for a proceeding, you're disciplinary, and actually what you're saying doesn't matter to that employer. You're, like ni kama ni mbuzi inapigia mtu gitaa. Umenielewa? Sometimes it is so important to know that even your employees are actually human. Number three, your employee deserves something called right of representation. They should never, ever feel like they are on chokehold and they cannot fairly express themselves. If they feel like they are not confident to talk for themselves in that proceeding, that disciplinary process, they have the right to actually access somebody to come and represent them. It could be a lawyer or it could be whatever they deem best, but they have the right to representation. Okay. Number three, they have the right to access the minutes of the disciplinary process, because sometimes you find that some employers, when they find that the case is not very strong and they want to really grill this employee mpaka aende nyumbani, what they do is that they doctor the minutes, especially on what every party said or what every panelist say or what the employee said, right? Because those minutes are the ones that are presented in a court of law or in public service in case the employee appeals that decision. So it is so important actually to know that the employee deserves all of that. So you cannot deny him or her that right. You don't have the power to do that, okay? Now, what is unfair termination? Termination is unfair if there was no valid reason. Sometimes you can just look at somebody na umchukie tu. I've heard that in so many working places where you just look at a person, the boss looks at the person, or the employer or the CEO looks at a certain officer, and they just don't like the officer. So what do? They just look for a way of getting that person out. Ya kukurig out too. Ni kama ni election. Like they have to find for a way to just get rid of you, okay? Number two, if there was no due process, which I've just told you, show cause, fair hearing, right of representation, and access to the disciplinary process meeting. If there was no due process followed, that is unfair termination. Number three, if there was no notice of termination or pay in lieu. Sometimes you're so in hurry to get rid of an officer that you just do a letter today and then you're telling the officer not to report tomorrow. That one cannot happen. It's not doable. If you actually do that, you're contravening the law. Okay? So if there was no due process, no notice of or payment in lieu. What is payment in lieu? Payment in lieu means if you feel like you don't want to work with me this month, then you will have to pay me for this month because you did not give me 1 month notice to prepare. So what shall you do? You will pay me because I was not ready to not be working at this time that you are telling me to go home. So what do? You pay me in lieu. Now that is called payment in lieu. Now, payment in lieu is also a term that is used when somebody resigns. When you resign, you have to give your employer 1 month notice to know that they will not be with you in this coming month. And in case you don't give the employer notice, what shall you do? you will pay in lieu because they didn't know that you won't be there. So what will you do? You will pay the employer instead 1 month's salary, and it is termed as payment in lieu of your 1 month salary because you have not given notice. Okay, so now the law protects both permanent and contract employee. I have been in so many environments, and I've noticed that anyone that is on contract, they are treated as half employee, and anyone that is on permanent, they are treated as full-time employees or bona fide. But now there is a problem because the law takes care of contract. Actually, I'll tell you something. Did you know that if you hire somebody on contract for like 3 months and you renew it once, if you go to court and the person complains that you dismiss them unfairly, actually the court will think that you should actually hire that person, because if you hired them twice on contract, it means that you need them. Okay, so it is so important to note that. Now, I want to get now down to, there are 7 mistakes that employers make when they are terminating. Okay, now the first mistake is terminating without a hearing. Remember, I said that the employee has a right to hearing, right? So the first mistake that employers make in termination of employees' contract first is terminating without hearing. Even for misconduct, hearing is mandatory. Okay, now that thing of saying come tomorrow for your letter of termination, na utoke hapa, sitaki kukuona hapa, now that one doesn't work. Legally, it doesn't work, and if you do it, it will land you into trouble. Number 2, now the second mistake why an employer may make some mistakes in terminating is using summary dismissal for everything. You see, summary dismissal, if I would use a legal term, it should be used for those capital offenses. Like, let's say a staff killed another staff, a staff hanged another staff, a staff committed fraud, they faked their certificates, but all of those things, they cannot be terminated. Now, let's say you just don't like the way I talk, and then you want to terminate me. You cannot terminate me summarily, right? No, you cannot do that. Did you know even gross insubordination, which most bosses like to use, should still be subjected to disciplinary process before you dismiss somebody? Okay, so don't use summary dismissal for everything, please. Summary dismissal is for gross misconduct only, which is fraud, forgery, faking, fighting, all of that. Okay, now 2, don't say that if somebody performed poorly that you're going to summarily dismiss them. No, you cannot do that. Instead of training the person, you want to dismiss them. How are you helping that staff? Right? Now, the third mistake that employers make in termination is verbal dismissals. Now, this one, I have to tell you something. In HR and professionally, if it is not documented, it did not happen. It's a rule. If it's not documented, even legally, if it's not documented, it did not happen, right? So termination must be penned down. It must be written, typed, printed, and then it should be signed. A senior officer, it could be the CEO or the HR manager or a certain senior manager. They have to write and commit themselves that they are dismissing this person. So verbal instructions have zero strength before the law. If you just wake up and say, you're fired. No. I would want to say this. I once went to a certain meeting, and then there was a certain person, and she said that, I noticed that in Kenya, it's so hard to fire somebody. In my place, we just fire easily. But here in Kenya, because the law in Kenya, now the employment law is very, 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 very strict. And I feel it is something that we can even be so proud of, right? Because our ELRC, our Employment Labor Relations Court, is very, very strict, right? So no verbal instructions, and it has to be penned down. Now let's go. Now the fourth mistake that an employer makes in terminating the contract of an employee is accusing employees of absconding incorrectly. What is absconding? It is like absenting yourself from work without permission or without official, release, like leave or off or sick leave or sabbatical, study leave, or whatever it is. So if you absent yourself without all of that, that is called desertion or absconding. Okay. Now, absconding means for it to be legal to dismiss somebody on the basis of absconding, first of all, it should be an explained absence. Unexplained absence. Number two, attempts to contact the employee were not successful. Let's say mtu tu ameingia tu mitini apatikanangi. Now, that one makes sense, right? And that can also be called desertion, right? Now, you cannot abscond after dismissal or communication. If I told my boss on Tuesday, I don't plan to come to work, that boss cannot charge me with absconding. That will be so unfair. It will be very unfair. The boss cannot charge me with absconding, okay? Now, the fifth mistake that employers make when dismissing employees is something called falsifying disciplinary records. I told you that the disciplinary process minutes are very essential in a court of law proceeding, and the employee has the right to access those proceedings, right? So those proceedings are so important, and they have to be recorded in minutes. Okay, now why the employee must access those minutes is because the employee must be sure that what is in the minutes is also what is in his head. His conscience must agree. His conscience must actually and completely agree with what is written, because he was the one that came for the hearing. You cannot say that he insulted the panelists when he's the one that came to the hearing, and he knows that is so out of character for him, and then you inscribe it in the minutes. That is being so unfair, that is being so rude, and that is being so unprofessional, right? So sometimes the employer, because they just dislike the employee, they can fake the minutes, right? They can actually fake the minutes. And when they fake the minutes, they will actually make sure that they hide the minutes from the employee. And when they hide the minutes from the employee, now that becomes a legal issue, because it will be, now if the employee appeals before the Public Service Commission or goes to a labor office or goes to the Employment and Labor Relations Court, if they find that those minutes are falsified, the employee has a right to seek an appeal elsewhere, and actually the judges or the tribunal can actually throw off the case, because that now speaks to the lack of integrity of the employer, and that is very, very wrong. It looks so bad in the eyes of the law. Okay, now so the sixth mistake that an employer makes makes in terminating the contract of an employee, and this one I have to talk so categorically because it's so important, is ignoring contract terms. Contracts, when everyone is signing the contract, the employer will sign to make the contract valid, and then the employee will sign to show acceptance of the contract. Now, sometimes you find that you're dismissing somebody and you're just telling them, don't come tomorrow, when this employee has the original letter of the contract at home. So what do employers do sometimes? They ignore notice periods. So they just tell you, go. You have to give me notice. Sometimes for contracts, sometimes for a short-term contract, it could be 7 days notice. Some contracts will say 21 days notice. Some contracts, especially if you are hired permanently, they will ask for 30 days notice or pay in lieu. I hope now you remember what is pay in lieu. It is, it is payment to cover that time that the notice was not given adequately, right? So they also ignore gratuity clauses. You can find that it was agreed that at the end of the contract, it doesn't matter how the contract ended, it was agreed that the employee will be paid gratuity. Maybe it could be a flat rate of 1 month's salary, or it could be maybe a percentage of every month's salary, maybe basic salary or gross, whichever you people decide. Now, you have to know that if you ignore those clauses, the employee will produce the letter. Especially if they see this video, they will produce the letter before a tribunal or a court, and you will lose that case. And by the way, guys, let me just tell you, to be clear, employers, you must know this, that the court will always side with the employee, especially if they find just one loophole, they will always side with the employee. So the Bible says, agree with your adversary, mapema, before they take it to court. So just make sure before. Also, there is a, like jurisprudence has designed it like that, if you have to go before the court, or if you have to take me to court, you have to come with clean hands. So you, employer, make sure that if you will appear before court, you will come with clean hands. Make sure that if it's gratuity, you paid. If it's final dues, you paid. Make sure that you gave notice. If you do all of those things, and the reasons that you fired the person are actually adequate to fire someone, then you have come with clean hands and you can win, right? But always know that the court always supports the employee. I've told you. Now, the seventh mistake, which will be the last one because I told you about it, withholding final dues. That is a mistake that most employers do. They will tell you, I will pay you, we will pay you, because final pay is a right, not a favor, and clearance delays don't cancel entitlement. Let's say the employee never went for leave because you wrote and said there is an exigency of work, so the employee must stay kidogo, so that we finish these targets. Now, you have to pay, you have to compensate that employee for that period, because if they go to court, they're gonna win. And once they win, you're losing, right? Now, what employees should do immediately after you're terminated unfairly? The first thing is ask for written reasons. And you see, if you do it fairly, in the show cause letter, you write the reasons, right? So ask for written reasons as to why your contract is being terminated or your employment is being terminated. Number 2, request for disciplinary records. Why? You want to make sure that whatever is there is the truth. Because some employers, when they want to get rid of you, they will do anything. So what do? Ask for disciplinary records. Number 3, preserve evidence. Maybe if you're texted, ukaambiwa you're fired, usikuje kesho, there is a text, right? There is an email, or there are people that so you can talk to those people, talk to them. Don't coach them though. Just tell them to say the truth. The only truth, the whole truth, okay? Yeah. Now, the 4th one is write a formal objection. If you feel it's unfair, do it formally. It could be through an email, through a letter. Do it officially and formally, okay? And then, let's say if things are not handled well, where do you report? The first place that you should step is labor office, because now labor officers are not lawyers, okay? They may be human resource officers or practitioners, but they are not necessarily lawyers. So what do? They mediate. So let's say, like you're saying that you have not been paid your final dues. A labor officer will write to your employer to tell them that you came to complain. Now, an example of places where you can find a labor officer is a certain office called the Office of the Ombudsman in Kenya, right? And that one mostly helps government people, but it can help you as well. So you can go there, you find labor officers, and they will actually come to your employer. They can even do a visit because they are paid for that. They can do a visit and come to your employer and ask them, Kwani, what happened? Right? So you first visit a labor office. Number 2, if the problem is too grave and your grievances are not hearkened to, and you're not getting a positive reply, what do? You now escalate the matter to ELRC, Employment and Labor Relations Court. Okay. Now, this also has to be within, don't wait for so long. Make sure before 3 months, 6 months, exhaust all of that. Okay. Now, you have to understand that I'm talking to you because maybe I have experienced it, or I've been in an environment that people were wrongly treated and I felt it, right? And I just wanted you to get educated so that next time you're faced with a disciplinary process, you know what to do. Document everything. Don't be lazy in documentation. That is what will help you. Keep the dates, keep the screenshots, keep the messages. Don't delete so quickly. Keep all of them. And so that you be safe in those messages, always reply your employer well. Don't be the one that will now go to court. Remember, if you're going to a court of law, come with clean hands. Sindio? Now, so if you liked what I shared, guys, please go ahead and subscribe to my YouTube channel and like this video, comment. And if you really liked what you heard, just comment with just, say what you want us to cover next. You will tell me which topic you want us to cover next, because depends on who is being affected. You can ask your questions. I'll take them in the next episode, okay? So I'm yours truly, your favorite HR team, and I want you to be the best employee. And for you, employer, I want you to handle your employees in a way that you will not be in the wrong side of law. So always make sure that you're court compliant and your Employment Act compliant. And you, employee, meet all your KPIs. Don't be a person that is always on the wrong side of the employer. Why you? Why only you? But in case you are unfairly treated, I've given you the antidote, okay? You guys, I'll see you next time in a few days. Adios.